Hello and welcome to today's webinar. My name is Stacey Sinclair and I'm the co-organizer and host of our Fenwick Elliott webinar series, along with my fellow partner Jeremy Glover, who you may have seen previously. But thank you very much for joining today. And for those returning, of course, a very warm welcome back. So today we are talking about building safety remedies. And this, of course, includes remediation contribution orders, building liability orders, and so forth. A very timely topic, as recently there has been a small flurry of activity in the courts regarding these remedies. And to take us through where we are at here, I'm very delighted to introduce to you our panel today. First, we have Lucinda Robinson, my fellow partner here at Fenwick Elliott, who specializes in construction law, all forms of dispute resolution, and is particularly close to the developments of the Building Safety Act and all related activities. And next we have David Pliener, KC of Gatehouse Chambers. David too is an expert in construction and engineering disputes, as well as insurance, commercial work, property damage, and professional negligence work. And also, thank you, Helena. Helena White is also from Gatehouse Chambers, who focuses on construction and engineering disputes as well, professional negligence and property damage. Helena's experience also includes public procurement and utilities works, but all three regularly are advising on the Building Safety Act, and we are delighted to have them here today to take us through these developments. But just very quickly, a bit of admin from me. Everyone is on mute in the usual way, and to the right you should see a panel with a questions toolbar there. Please do pop in any questions you might have as we go through, and we will try and take as many of those at the end if we can. Now, the slides, which you'll see in due course, will be available on our website, as well as an on-demand recording of today's session. So with that, welcome everyone, and thank you very much, Helena, Lucinda, and David, and I will pass over to you, Lucinda. Thank you.
Great, thank you, Stacey, and good afternoon, everybody. So let's ease into the discussion with a few things you already know. So the Grenfell tragedy has led to some dramatic reforms with the introduction of the Building Safety Act 2022. This was introduced to make buildings safer in future and ensure developers funded the remediation of non-compliant buildings that they had delivered. And one of the ways it does this is to introduce new ways for those affected by building safety issues to recover the costs of remediation. And the developers were the main target. But making developers pay does pose some challenges. What if the developer is an SPV without any assets, or who has folded once the development had completed? Or what if the developer's assets were moved out into other group companies where they couldn't be reached by the claimants? In these cases, either the developer no longer exists or is not worth suing. So the government came up with some new ideas, specifically to enable claimants to get group money, remediation contribution orders and building liability orders, or RCOs and BLOs as we may refer to them here. So RCOs and BLOs have a lot in common with each other. Both are brand new creatures of statute and didn't exist before the Building Safety Act. Both have been subject to some recent cases, so we're beginning to understand a little bit more about them. And both seem to pierce the corporate veil, allowing access to cash within a corporate group in quite a dramatic departure from the company law principles as we've known them for years. But they only do that when it is just and equitable. So what on earth does that mean? The Building Safety Act doesn't tell us, but hopefully David and Helena are going to help us understand. David's going to talk about RCOs. Helena's going to cover the very recent Vista Towers case and what just and equitable might mean for RCOs, and then I will have a look at building liability orders. So on that note, David, over to you.
Thanks, Lucinda. Morning, everybody. As you're about to discover, I'm incapable of pressing whatever button it is that I'm meant to press to make the slides move. So Lucinda is going to press that button for me in a tag team system that is bound to work. And thank you, Lucinda, you've put this on first. So I wanted to kick off with a warning and an apology. So as Lucinda has said, and as you know, this is a very new scheme of remedies, new That is in legal terms, it's been here for 3 years. For us, that is extremely new. When I was at university, which I appreciate was still some time ago, I had a land law lecturer who would keep talking about the new act. And it took me a while to work out that what he was referring to as the new act was the 1925 Landlord and Tenant Act. So as lawyers, it does take us a while to get our teeth into things. So if you were hoping that you'd come on this talk and go away with lots of clear answers, I'm afraid you might be disappointed. But we are just starting to get a trickle of cases coming through, and the Court of Appeal are about to hear a case which we think will give a lot more guidance on RCOs, particularly next week. So we're going to do our best to update you on where we've got to, in the hope at least that it will help you make sense of what is going to come next. Next slide, please.
It's getting there.
Fantastic, thank you. So let's just briefly remind ourselves of the basics. And what we've put up for you on the screen there is the definition of what a remediation contribution order is, with a bit of magic interposing of what some of the other sections mean in order to help make sense of it. RCOs allow the first tier tribunal to require someone to contribute to the costs of remedial work to correct a relevant defect. A relevant defect is something which causes a risk to people's safety due to the spread of fire or building collapse. It can be applied for by an interested person. These are the key building blocks of the section. An interesting person is Secretary of State, you can see it at the top there, other people, but including anyone with a legal or equitable interest in the property. Also, crucially, who can it be made against? It can be made against that list of bodies at the bottom. So that is effectively the landlord, or whoever was the landlord in February 22, the developer, or a person associated with any of them. And each of those bits has some definitions. Certainly the person associated does. But the key bit, perhaps, is that, as Lucinda said, even if you meet all those criteria, an order will only be made where it is just and equitable. And for today, at least I'm going to be focusing on that last crucial question. First, though, it's worth remembering that this question is not, at first instance, decided by our very own TCC, the Technology and Construction Court. It's decided by the first tier tribunal, the FTT. Now, I have some excellent colleagues who work as tribunal members in the FTT, so I thought I'd check what kind of reviews they've been getting in doing that work. And Lucinda's going to change the slide so you can see some of them. You can see what they say there. Extremely unfair and unreasonable and rude, unresponsive, don't reply, dangerous and non-compliant. Well, okay. Well, those reviews were from 4 years ago, so I'm sure it's much better now, right? Let's see what we've got from this year. In fact, I think this is the end of 2024. Horrendous, avoid at all costs, unable to fulfill the job role, an unpleasant horror of a human being. Actually, I think that is one of my colleagues. Anyhow, look, I guess whilst you can't please all the people all the time, the more serious point for our purposes is to recognise that this remedy will at the coalface be adjudicated upon by something outside of the more mainstream TCC home that we know and love. What you would then have normally is an appeal from the first tier tribunal to the upper tier tribunal, and then from the upper tier tribunal to the Court of Appeal. Although, as it happens, the big decision that I'm going to be looking at, triathlon, was done in a way, for reasons that you don't have to worry about, which means it's gone immediately from the first hearing to the Court of Appeal. Okay, so pending that decision, which will no doubt take a few months at least to come out, even after the hearing, what do we know so far? I'm going to look at triathlon, which is one of the main cases that we've had and is the one that's going to the Court of Appeal. And Helena is going to look at a couple of cases that happened since then to see if they tell us anything more. So turning the slide, please. In order to talk about triathlon, I need to ask you to turn your minds back to the heady days of London 2012. And I'm sure, just like you, I was sitting there watching those wonderful scenes on TV, gripped with excitement, wondering if the hastily constructed infrastructure would keep us in work for the next decade or two. Well, friends, fear not. Turning the page, you are probably all familiar with, or at least heard about, the triathlon case. But since it is one of the very few cases in RCOs, and it's about to go to the Court of Appeal, I'm going to talk about it in a little more detail. This is what you need to know, the basics. The dispute concerned the buildings initially constructed to house the 17,000 Olympians, and then subsequently it was redeveloped for social and private housing. You can see the list of the various interested parties. SVDP was originally incorporated as a public body by the Olympic Development Authority, and it remained publicly owned until 2014. There was then a sale and purchase to the Qatari company that was inevitably a subsidiary of the Sovereign Wealth Fund of Qatar, and in 2018, part ownership transferred to a Canadian investment company. Get Living from 2018, November 2018, was interposed as a parent of SVDP, and it owns the private housing. Triathlon holds long lease of the social or affordable housing, and EVML is responsible for repair and maintenance. We're going to talk about each of those companies in a minute. Turning the page, please. Triathlon applied for an RCO against SVDP and GL as an associated company of SVDP. So SVDP as the developer and GL as an associate of them. The central question was whether it was just and equitable to make the order, particularly in light of the fact that EVML was already undertaking the work, and that work was already being funded by the BSF. Triathlon, if you press the button here, something might happen, Lucinda, with a bit of luck. Oh, keep pressing. I hadn't realised I'd divided it up in this way. Triathlon argued that there was a presumption that if the requirements were met, in other words, there was a relevant defect and there was a landlord or a developer that met the criteria, then there was a presumption that if there's a landlord or developer with the money, it would ordinarily be just and equitable to make an RCO. And they relied upon these three things that you can see set out there. The LPI regs are the Building Safety, Leaseholder Protections and Information regs from 2022. And they're also made under the provisions of the Building Safety Act. Regulation 3 of those regulations say that where a landlord is liable to pay for remedial works, it is entitled to recover from its superior landlord, entitled. So Triathlon said, you can see therefore that the tenor of the Act is, and the approach of the Act, is to make it an entitlement. Secondly, they pointed to ministerial statements made in Parliament, which they say also showed that it was meant to be effectively a presumed award. But as you may or may not know, as a matter of law, you can only look at what ministers say in passing the Act if there's an ambiguity in the Act itself, and there probably isn't one. They then pointed to the explanatory notes. Now, explanatory notes are admissible in trying to construe what the hell the Act means. They're described as being a secondary aid to interpretation. Triathlon said that those explanatory notes were consistent with there being a presumption. Now, we'll hear more about those explanatory notes from Helena, because there's been some interesting comment on them in subsequent cases. But for present purposes, and pressing the button again, please, the tribunal said that the explanatory notes didn't take the matters much further, and therefore they concluded there was no presumption. And you can see, I think, from that quote, which I'm not going to read out, that actually it's talking about the factors, but it's not making a presumption. So they didn't win on that. Let's see what else was talked about in triathlon. Another question which arises before looking at the detail of triathlon is, can we glean any insight from looking at the cases which are dealing with remediation orders under section 123? So these are orders which are made which allow you to require somebody to carry out the work, whereas a remediation contribution order is somebody's carrying out the work and I want you to contribute. On the face of it, it seems unlikely that those cases will help because the remediation orders don't have a just and equitable test. But in that grey case that I've set out for you, the FTT said, well, we don't just have a power to order a remediation order, we do have a discretion. And although they don't describe it as just and equitable, one can imagine that any exercise of discretion feels like that's what they're going to be grappling with. But in that case, they said, well, RCOs are very different. RCOs are focused on the role of what's described as the polluter, the wrongdoer, as opposed to just getting the work done. And RO, remediation order cases, just weren't referred to in triathlon at all. Next slide, please. The tribunal in triathlon noted that it was, however, very familiar with the test of just and equitable in other situations under other statutes, and I've set out some of them there. But the tribunal didn't refer to any transferable principles that would help us work out how to actually apply it for remediation contribution orders. And as the quote suggests, which you can see, and again, I'm not going to read out, essentially all that had been said in those other jurisdictions were, well, you take everything into account. Great, that doesn't really help us. So what might help us if we turn over the page? In triathlon, the tribunal did comment on an array of factors which were put forward by the parties as being potentially relevant. They, I wouldn't say criticised, but they commented that triathlon was casting a very wide net, in case you're wondering what the hell that's doing there. And the batch of points that I'm going to look at first, the tribunal in triathlon said that these were really only points of context. They provided context, as opposed to being the important issues which decided the case. So let's have a look at those and see what you think. The first one was the role of the parties. There was lots of argument and evidence in the case about whether the Qataris or triathlon had control or knowledge about the use of the dodgy cladding. But the decision was on the facts that they didn't. So in this case, the question of the role of the parties wasn't relevant, but it was left open, I think, as to whether it might be relevant on other facts. Next factor, please. The tribunal were almost completely uninterested in why triathlon sought the orders in circumstances where the works were already being funded by the BSF. Parliament said the tribunal had granted the power and triathlon was entitled to apply for it, to which my comment, in advance of what the Court of Appeal might say, is sure, but surely it's also a relevant factor in whether it's just and equitable in deciding to make the order. Not really very excited about that, the tribunal. What about the next one? In similar ilk, the tribunal was not interested in arguments about whether there were remedies available, alternate remedies available, triathlon. The respondents had argued, well, look, triathlon has a contractual right, has DPA, Defective Premises Act, claims against the rest of the project team. In those claims, the court could apportion liability under the Contribution Act. That's fairer than under the RCO regime. You shouldn't allow, they said, the RCO regime to outflank the contractual scheme. The tribunal said no. Parliament intended this as a parallel right. It didn't require it to be subordinate to existing remedies. To which again, I would say, well, okay, but surely whether or not the applicant has alternative remedies available to it would be an important factor as to whether making the order is just and equitable. According to the tribunal in triathlon, not very much. How about the next point? Again, tribunal didn't really care, for example, that EVML, the party actually carrying out the work, could have applied for a BLO themselves, a building liability order themselves. Again, didn't take away from triathlon's right. Next point. This is an interesting one. The respondents argued that the SVDP, the developer of today, is not the SVDP that designed and built the blocks. And that was because the ownership structure was completely different. The people that owned and ran SVDP at the time of the design and construction had no resemblance to the people who owned it now and were the ones who would have to pay. Now that might sound like an obviously bad point because it's the same corporate entity and we don't go behind corporate entity veils. But as I suspect you can see why, I think it's quite an interesting point because the respondents said, look, the Act ignores corporate distinctions. So why are you not entitled to look behind the corporate veil for another related purpose when you're asking whether it's just and equitable? And the tribunal said, no, you're only allowed to do that for the specific limited purpose allowed for in the Act. But again, why was that not a more important factor? Isn't it at the very least worse in some manner if the people running and owning SVDP were the same people as had designed and built the cladding that is causing the risk? Tribunal didn't seem to think so. 6th point, very little relevance, they said, in the fact that Get Living's investment in the property had increased in value. And finally, individual leaseholders gave evidence of the impact that all this had had on them, and the tribunal said, well, that evidence could be of paramount importance if the works were being delayed due to funding, but that wasn't the case here, although one might wonder why, if the works weren't being delayed due to funding, we weren't looking at a remediation contribution order at all. Going to the next page. So what were the facts that the tribunal did think were important? Which ones hit the mark? So the first point was, bottom line, SVDP was the developer. And the policy of the Building Safety Act, they said, was that the primary responsibility for the cost of remediation should fall on the developer. Now, by the way, I'm not sure it actually says that anywhere, but that's what the tribunal said. And they said that, you remember the LPI regulations, they said the fact that the LPI did contain a remedy for recovery from SVDP as of right was relevant. Again, one might think it was relevant as a reason not to provide an alternative remedy, but they saw it as a reason to provide one. What about the point, as we can see there, that the whole purpose was said to be, the whole purpose of an RCO was said to be to ensure the work was done swiftly and was fully funded. The tribunal found on the facts that it was unlikely that funding from the BSF was at risk, and that there was only a modest risk of any shortfall. But they said any uncertainty was undesirable. And I think that key point might underplay the role that point will make in the Court of Appeal, bearing in mind that the raison d'etre of an RCO is supposed to be to get the thing swiftly built and fully funded. So then the question was, on the next bullet point, why shouldn't we leave the funding to be from the public purse? EVML are carrying out the work. Why don't we just leave them to recover their remedies from others? And so, in my view, we get to the crux of it in a neat, clear, on one view terrifying, on another view reassuring quote that is set out at the end. And if we can just press the button again to get the quote, please. After 55 pages, is the quote coming up there? One more press, maybe. There it is, thank you. After 55 pages, and having rejected the idea of there being a presumption, the tribunal basically said, as you can see there, it will always be just and equitable if there's a party coming under section 1243 that can fund it. Well, thank you for that merry-go-round. Turning over, what then about Get Living as the associated company? We don't really get very much comment on that in the case. Put simply, if it was just and equitable against SVDP, it was pretty clearly just and equitable against Get Living, thought the tribunal. And now, before turning to Helena to take it from there, the question is, what's the Court of Appeal going to say when they hear this? I think it is next week. Well, of course, I don't know. What's my best guess? My best guess, and you'll all be able to prove me wrong, is they'll probably come to the same result, but I think for different and better reasons. But I do think the fact that this project was already being funded and being undertaken so that there was no real risk that it wouldn't get done does make it quite a close call. Either way, we'll learn a lot more about the approach likely to be taken by the courts and the FTT in the future very shortly. And with that, I'm going to pass on to Helena to take it from there.
Thanks very much, David. So a few weeks ago, we had the pleasure of an approximately, I think, 133-page decision in the case of Gray and Edgewater. I've been referring to it as Vista Towers because that's the name of the building, and you can see the lovely building there in the picture. It's the classic tale of woe of a building that has various issues with fire stopping combustible materials in the external walls, no cavity barriers, and various other fire stopping and safety issues were alleged. So the applicant in the case had purchased the freehold from the first respondent in June 2018 as part of a series of ground rent investments, and so was the landlord. The first respondent was effectively the developer. He had developed the building from offices to a residential block some time ago. The other companies that were respondents, and I'm not going to go through them all because there were 96 of them, were companies with various connections with the first respondent and its directors, including a lot of family and community connections. So ultimately the question for me, I suppose, is whether the Vista Towers case moves things on in any material respect from Triathlon. I think the answer with all these things is yes and no. There are some clarifications, some additions, but I would say nothing seismic. I mean, that in itself is helpful to know. Although, as David has been saying, it's all in the shadow of the Court of Appeal decision in Triathlon that is going to provide the definitive view, we hope, on the issues that the FTT have been grappling with so far. So looking at the issue of relevant defects and how the tribunal deals with those, importantly, I suppose, although there was argument to the contrary, the tribunal confirmed that there was no reason to confine relevant defects that would qualify only because they are a breach of building regulations. The wording of the statute is that the defect can be anything done or not done, used or not used, which I think you would agree is one of the widest formulations you could think of. The second necessary condition is that the defect causes a fire safety issue. So it doesn't necessarily bring building regulations into play, but obviously most defects are likely to also be breaches of building regulations, although it's not a necessary condition in and of itself. Then when thinking about relevant defects and what the tribunal is going to do about them, there is a separate and further question of whether remedial works in relation to those defects are reasonable or reasonably required. And in the Vista Towers case in particular, because the works had already been carried out, they decided that in line with the type of approach that parties take when assessing what remedial works are proportionate and actually required to make a building safe under the PAS 9980 guidance, it's clear that the tribunal isn't necessarily going to allow sums to be paid in respect of all the remediation works carried out in respect of all defects, only those that are reasonably required. But thinking about the scope of the remedial works that the court is likely to allow. So I'm just trying to move on my, there we go. So of note was that when thinking about, oh, I've got, I've gone far too far. I'm not sure I know how to go back. No, hang on,
let's have a look. It goes slow and then goes quick. So you have to.
Thank you. I think I possibly demonstrated that I need to practice my grasp of technology, but my grasp of RCAs is far better.
Tell me when to stop.
Go back to the scope of remedial works, like that one. Thank you, Lucinda. Much appreciated. So in thinking about the scope of works that the tribunal is going to allow to be funded, the tribunal said that essentially that there's no need to find that the risks are intolerable before they are remediated. Any risk that is above the low assessment that you would get under the PAS 9980 scale, which sort of means that it's low risk where fire spread is within normal expectations, anything above that test should be remediated. And they would be looking for costs that fall within a reasonable range where they acknowledge that the range is going to be wide. Although it wasn't mentioned in the case, it seemed to me that when as in Vista Towers, costs have already been spent in respect of remedial works already carried out. It put me in the mind of the court's classic approach in the Siemens and Super Shield case, where with which people are probably familiar, but in summary, to the extent that you as a person carrying out the works have relied on the reasonable advice of advisors when settling or paying an amount, the court shouldn't ordinarily look behind the costs that have been spent or the settlement made. You do have to show that there is a connection between the alleged breach, or perhaps more apt here, the relevant defects and the costs incurred. But once you have shown that connection, it's not necessary to dig too deep into the appropriateness of the costs of the remedial scheme. Obviously, what's going to come up quite a lot in these sorts of cases where works have been carried out is that people have been carrying out works in order to ensure that they can get a grant from something like the BSF, or in order to meet various standards. And what the tribunal seemed to indicate is where you've carried out works in order to try to meet those standards, then those should be recoverable. So to the extent that the tribunal looked at concepts of what is just and equitable, they essentially followed on from what the court has said in triathlon. There are perhaps a couple of points to highlight. They confirm that there is no automatic presumption that an associate should be liable unless they, the associate, can show that there is a good reason not to be made subject to an RCO. So I think that means that the implication is that the burden remains on an applicant to make out a proper case, and further that the tribunal must consider all of the facts, starting from the end of the telescope, that no RCO should be imposed unless it is just and reasonable, rather than saying that an RCO should be imposed unless it is just and equitable not to. So that those things aren't just semantics, and that there is a big mind shift between those two, as I've called them, sort of ends of the telescope. The tribunal also talked about the relevant linkage, which is not one of my favourite words, but the links between the a link with a party who is an associate. That the links are to be considered on a no-fault basis. So as David was saying, you're essentially looking for the money, but that does fall short, they said, of some sort of tracing exercise. As a point of interest, the tribunal made clear that impecuniity wasn't a factor that they thought should militate against a RCO being made against a particular respondent, perhaps hoping, as people do, for some sort of lottery win at some future point. I'm not sure that that decision would be made in every case, especially given the point of section 124, as opposed to the BLOs that Lucinda's going to come to talk about, is that money needs to be provided quickly because remedial works have to be carried out quickly. But again, it's just going to be one of the circumstances of the case. And it struck me when I was reading all of the 133 pages, and I'm not saying my mind was wandering at any point, but there may be a bit more nuance as to whether fault does feature when assessing just and equitable as a test. I suppose it's hard not to import some considerations of blameworthiness when the test you are considering is justice and equity. And in this case, the tribunal was willing to refrain from making an order against people they described as innocent investors, essentially people who had either at a later date become associated or become well, associated with the associated companies, and they were also keen to understand whether those companies had made a profit or got some sort of benefit from the project that had led to the presence of the relevant defects. They also noted that there may be some instances where an association would arise where the connection was essentially the wrong director at the wrong time, and that was a factor they were willing to weigh in the balance. Seems to me that those concepts do clearly connote some notion of fault, or at least blame by proxy, although on the other hand I can see that it might not quite be fault, where what the tribunal said they were doing is ultimately looking for commonalities that indicate a wider corporate structure, and the purpose was to try to find those the companies involved in what will often be on a big building project a wider corporate structure where money can be hidden. So that takes me on to the issue of hierarchy. So David touched on this, that in triathlon, where it was also described as the cascade of liability, they reaffirmed that it is the developer who is going to be the main target. Landlords probably come next and associated persons come after that, but it would depend who the respondents are. They didn't really give any other guidance about how the hierarchy works. I mean, on one view, perhaps it's not that complicated. So that they did make clear that leaseholders that are not protected by Schedule 8, which essentially means that leaseholders who have interest in the relevant property won't be made to pay for remediation, as David was saying, and that is the statutory protection. But the tribunal again made clear that even if you don't have those statutory protections and you are a leaseholder, they said that they are very far down the hierarchy. So I suppose it's not that they couldn't be left to bear some of the cost of remediation works, but the tribunal was extremely keen that they shouldn't feature. The bigger question from my perspective, I suppose, is whether the proper approach, given this hierarchy concept, is for the tribunal to ask itself whether the developer, being at the top of that hierarchy, is able to satisfy the entire liability of the remedial works, and if they can, then you don't have to look any further. Vista Towers clearly left open that possibility, even though it did make approximately 90 RCAs against the respondents. So that brings me on to the issue of joint and several liability, and essentially the question of on what basis the court should make its orders, or rather the tribunal should make its orders. So the statute gives the tribunal the power to make an order requiring a respondent to pay a specified sum in respect of the remedial works. For that reason, in the case, it was argued that the court should quantify the liability against each individual party rather than making a joint and several order against all the respondents made subject to an order. The court said that it wanted to make a joint and several order, so a global order that made everyone liable for the full amount. And it didn't seem to me that that would necessarily be the norm, and there's no particular starting point. It seems to me that the court, or rather the tribunal, should be making joint and several orders. The tribunal said that on the fact of this particular case, it was necessary because of the complexity of the web of connections between the various interrelated parties, united in large part by familial and other connections, where the record keeping of all of the companies nearly was extremely disorganized. The tribunal said, rather than anything more nefarious than that. But the consequence was that it was unclear where any money actually sat within the nexus of all the companies. They said it would be impractical to make a series of specific several liability orders, i.e. making each respondent liable for a specific sum only, such that the applicant would have to attempt to enforce each order one by one, perhaps returning to the tribunal if it transpired that money wasn't forthcoming from a particular respondent. And in essence, the tribunal said it was just and equitable to leave the pain of divvying up the liability to the respondents rather than putting that pain on the applicant. So my last comment moves away from the Vista Towers case and picks up, as David had mentioned, the BDW and Ardmore case, which is a recent decision concerning building information orders. So those are orders that you're supposed to be able to get to obtain information to help you decide whether you want to make a BLO, which Lucinda is going to come on to talk about it. And I mention it because a lot of weight has been given in the tribunal cases concerning RCOs to looking at explanatory notes so that the tribunal can ask itself what the intention of Parliament was when enacting the statute. In short, the court said that you should ignore them because they cannot, in any event, the court said, supplant the court's own reasoning or interpretation of a statute. Relying on various authorities, the court said that the explanatory note is not part of the statute. It is not drafted by Parliament. It's drafted by the government department responsible for the legislation, and so does not, on its face, reflect, in fact, the intention of Parliament. And in that case, the judge entirely disagreed with the contents of the explanatory note and the example given in it, saying that a building information order can only be made against the original company with the relevant liability. So the company essentially that committed the wrongs, and not the associated company who would actually be paying were a BLO to be made. I think the court's substantive finding is probably wrong, and I won't go into that in a lot of detail because it can be a whole new seminar for everybody at a later date. But just to touch on it, what the court had said was that the body corporate mentioned in section 1322A, so against whom an information order can be made, can only be made against the body corporate mentioned in that section. And he said it follows as an order for information can only be made against the corporate body that is subject to a relevant liability. But I think that if you look at section 132, which says that any relevant liability of a body corporate, so the original body relating to a specified building, is also a liability of a specified corporate body, so the people against whom the BLOs would eventually be made, which I think means on the face, the statute, for the purposes of the provision in any event, regards the relevant liability as being both that of the original company and the associated company. And I think that interpretation makes more sense when you're supposed to be able to get BLOs even where the original company is dissolved. And it's much more likely, it seems to me, that the existing companies who aren't dissolved are going to have documents that would help an applicant decide what it wanted to do next, rather than a dissolved company. But we shall see. So on that note, I'm going to hand over to Lucinda, who's going to talk about BLOs.
Great, thanks, Helena. Yes, so we're going to move on to building liability orders, if the slides will catch up with me. And I have to credit David for this particular slide, as I've borrowed it from him, and you'll see it looks a little bit familiar, similar to the one he showed you earlier. So turning to building liability orders, these are taking us back out of the first tier tribunal and into the High Courts and the TCC. The relevant section in the Building Safety Act is section 130, which you can see here. And there are some keywords highlighted and some additional explanatory information where needed. So working through what you can see here, the court may make a building liability order if it considers it just and equitable to do so. So we know the court has discretion, but we also know that it has to be just and equitable to make the order, and we'll come back to the meaning of that shortly. In the meantime, we can look at the rest of what this says. We are then told that a building liability order is an order providing that any relevant liability of a company relating to a specified building is also a liability of another specified company or companies, provided that second specified company is associated with the original one within the relevant period. So getting into the detail of all of that, first of all, you'll see there's several references to something being specified, and that is specified in the order or the draft order, building liability order, rather than in a claim or anywhere else. And breaking down the rest of it, we're going to have a look at relevant liabilities, associated companies in the relevant period, and this concept of just and equitable. Starting with relevant liabilities. These are covered by section 133 of the BSA, and there are 3 relevant liabilities listed here, and you need at least one of them. That could be a liability under the Defective Premises Act 1972. Section 1 of this says that a person taking on work in connection with the provision of a dwelling owes a duty to ensure the work is done in a workmanlike or professional manner with proper materials so that the dwelling is fit for habitation. The limitation period for claims arising before the Building Safety Act came into force is 30 years, and for claims arising afterwards, it's 15 years. Section 2A is similar, but it relates to work on existing dwellings, and it only applies from June 2022 forwards. So liabilities arising before then are not going to be relevant liabilities. The second option would be a liability under the Building Act 1984 for breach of a duty imposed by building regulations, except actually that hasn't come into force yet, so it won't work for the time being. And that leaves option 3, and this is the widest option of the lot. And this is a liability incurred as a result of a building safety risk. Now, we've heard this term before in the Building Safety Act, but each time it pops up, it's slightly differently defined. This time, it's saying in section 130, bracket 6, that a risk to safety of people in or about the building arising from the spread of fire or structural failure. Now, relevant liabilities were considered quite recently in a case called Southwark and Click. And here, the claimant right to manage company and the leaseholders sued the developer and sought a building liability order from its guarantor and grandparent company, Click Group Holdings. They were told they could not rely on Section 2A of the Defective Premises Act because the relevant refurbishment works that had given rise to the problem had been completed before the Building Safety Act came into force. But they were allowed to amend their claim to argue that the relevant liability was a building safety risk. And that building safety risk had been created by breaches of the development agreement and the lease, and they had resulted in structural and fire related defects. And they were able to rely on that, and they did go on to succeed and establish a relevant liability. So once you have your relevant liability, you need to see if you can identify an associated company in the relevant period. The relevant period is the time between when the relevant works commenced and the making of the order. So that, as you can imagine, could actually be quite a long period of time. It could be several years. And then you need to figure out whether in that period, in that relevant period, there's an associated company. And the test for an associated company is in section 131 of the Building Safety Act. And it's quite wide. I've tried to set it out in diagrammatic form here, but I appreciate there's still a lot of words, so we'll work in colours. So an associated company in the yellow box will be one that is, so company X, the defendant, company Y, a potential associate, will be associated if one controls the other or a third party controls both of them. Now, what does control mean? Well, it could be one of two things. So company X will control company Y if X possesses or is entitled to acquire any of the 4 things listed in turquoise on the right-hand side of the screen, which is essentially 50% or more of share capital, voting rights, income, or assets. Alternatively, X will control Y if X can control how Y's affairs are carried out, either directly or indirectly. And in Southwark and Click, they said that this had happened because the defendant was wholly owned by one company who was wholly owned by another. So you have a parent and then a grandparent, and that grandparent company, who was ultimately the subject of the BLO, that company had the power to influence and direct what the defendant, company X, could do. So they were associated. And the judge also looked at whether or not the 2 companies or 3 companies had the same directors, which in effect was the sort of same controlling mind of those companies. So that's the sort of thing that will demonstrate some form of control. But how would a claimant know the detail of who had control within a corporate group? The starting point is sometimes Companies House, working backwards from the particular defendant that you're dealing with. There may be some records on Companies House that will show you who the directors are and who is the party with ultimate control of your defendant. That will give you a starting point. Or failing that, you can go for a building information order, as Helena has already mentioned. And the rules for that are set out in section 132 of the Building Safety Act. However, in the case that Helen has already mentioned, BDW and Ardmore, the court indicated that it's not necessarily easy to get an information order. So in that case, it was clear that you won't get one unless you can specify very particularly the building in question and the liability in question. The court said it would be quite slow to order disclosure of what is commercially sensitive information. In this case, BDW had a massive shopping list of information that they wanted to get out of the Ardmore group, and the judge wasn't having any of that. And as it stands, and as Helena says, this may or may not be right, we'll have to wait and see what happens later. But at the moment, they can only be made against the original company. So your defendant is the party that the order would be made against. And they are the party that would have to provide the documents. Of course, actually, they might not be the company that has the documents. So we'll have to see a little bit further on down the line how these pan out. Anyway, once you have got hold of your relevant liability and you've identified your target associate company, the big question is it just an equitable for that associated company to pick up the tab? But what does that mean and how do you prove it? And as we've already seen with remediation contribution orders, it's not clear from the Building Safety Act itself. And so we're reliant really on what the judges have to say. And in the context of building liability orders, the main decisions so far have come from Wilmot, Dixon and Prater and Southwark and Click, which I've just put the names of on that slide there. Both of these cases, or all these cases, were decided by Mrs. Justice Jefford. And pulling out the key points that she's made so far, this is where we get to. So the concept of just and equitable, no surprises, is deliberately wide so that the purpose of getting to the money can be achieved. And as we know, the court is going to have a wide discretion, and that will mean that it will consider all the circumstances and specific facts of each case. And they might include, for example, whether the defendant has any money. And this has been touched on earlier. If the defendant actually does have the money and it can answer the claim, then maybe it's not just unequitable to go after another parent or associated company, particularly if those others had nothing to do with the development and perhaps are in the control of other directors or further removed from what's been going on. Conversely, if the main defendant's insolvent or clearly has insufficient assets to actually meet the claim, then it is going to be easier to justify going to a parent or an associated company to get to the cash. And that has been the story in the cases so far, where actually the defendants in question have really been either on the brink of insolvency or there already. So if the main defendant has just another point to look at is the fact that some defendants in the past certainly have perhaps moved assets around so that they can lose them in the corporate group and the claimant can't get to them. So this was the story in Wilmot Dixon and Prater, where the Prater group companies had moved assets around and the original defendant had literally been asset stripped. There was nothing left there. Now, this is exactly the sort of situation that building liability orders were designed to address. So if there has been asset stripping, even if it was innocent, then chances are a building liability order will be made, particularly if the defendant itself has been left with nothing. Looking at another point, in Southwark and Click, it was decided it would be just and equitable to make a building liability order against the associate here because the defendant was in liquidation. It had only ever been a thinly capitalised SPV, as we know, the sort of exactly the point that BLOs were here to deal with. It had been dependent on the associate for finance in the past, and consequently, it was more likely than not it was going to be just and equitable to get to the money. Furthermore, in this case, the associate, which was a grandparent company, if you like, had guaranteed the liability of the main defendant in relation to the underlying project anyway, and this was a way of giving the claimants a direct route to the money that the associate had always sort of had in mind to provide. And also in this case, the judge went on to make that building information order too. And I think here she was conscious that actually, even though a building liability order was going to be made against that D2, the associate, that company didn't have a huge amount of cash either. And it might be necessary for that claimant to get to more of the group companies if it was going to recover the money that it was after. So again, we're really looking here at the situation with the defendant and whether it has any money, and if not, it is more likely than not that a building liability order may be found to be just and equitable. We can also take a little bit of guidance, and it is just a little bit of guidance, from Hansard and the debates in the House of Lords when the Building Safety Act was going through Parliament. The factors that were suggested there could be taken into account was whether or not the associate would have a fair trial. And the Southwark case picks up on this as well, because it suggests that the concern was where an associate has not been involved in arguments about liability within the substantive case, then it may not have been able to input into issues that might influence a decision on whether it would be just and equitable to pursue it. And it also mentioned the extent of the damages sought. So that's what we can take from the decisions in the courts so far on when it will be just and equitable. But assuming it is, or you think there's a good chance that it is, when do you actually make the application? Do you do it at the beginning when you issue your claim to do with the main liability in the first place and pull in the associate or alleged associate into the main proceedings, or do you wait until you've got a judgment against the main defendant and then do it? Well, as it turns out, the answer is, doesn't matter. You can apply at any time, it seems, as you can tell from my spring-themed chicken icons here. So, taking these cases in turn, BDW and Ardmore, here the judge made the point that building liability orders could actually be obtained on a contingency basis. So before you've even established liability, you could potentially get a building liability order on an if basis, i.e. if it's established that there's a relevant liability, then the building liability order will be made. And there you go. He actually used the word indemnity here. So this is quite interesting because it suggests you can get one really, really early doors. Now, one of the points the judge made here was that if a defendant has actually been dissolved already, then this setup here might actually obviate the need for them to be restored to the register for a claim to proceed against them. And he also pointed out there was nothing in the Building Safety Act to prevent this from happening. So off you go. In Wilmot Dixon, here the claimant started the building liability order process right at the beginning with the main action. So when they issued the claim form, the building liability order proceedings were swept up within that. And the judge said this was fine. Now, the defendant had said, well, hang on a minute, we're not happy with this. Surely you've got to establish liability and then go for your building liability order. Let's stay the building liability order part of the proceedings until liability is established or not. Otherwise, we've got to spend a whole heap of time and money defending a case that may never be relevant to us. But the judge refused that stay and said, no, there's nothing in the BSA preventing the building liability order being dealt with at the same time as the main proceedings. And actually, in many cases, that would be the sensible and efficient thing to do. And managing the costs of the associates in that situation is just a question of good case management, which the courts will be able to do. Now, she also went on to say that doesn't prevent a judge from deciding actually they will wait until the main proceedings have established liability and deal with the BLO in a separate hearing later. And that, in fact, is what happened in Southwark and Click, where the decision on liability was made first, and then the parties came back for a separate hearing on whether it would be just and equitable to make the building liability order. And in this case, as we've discussed already, the judge did make the order. So all in all, it seems you can apply for BLOs at different stages of proceedings, and you can have more bites at the cherry. So you could go for, as in Southwark and Click, a building liability order against one party, and then go and find some more information and come back and seek another one later, which might be a useful thing to do if actually it turns out that the original associate you go for doesn't have as much money as you thought they did, or actually if you don't know that there is another associate out there who would be good for the money, and you need to come back later. So that is it on building liability orders, and that should bring us up to the end of the presentation. So there we go. Thank you, David. Thank you, Helena.
And thank you, Lucinda. Thank you both, David, Helena, my thanks as well. That's been fantastic. I know there was a lot to get through in an hour, but that's been really, really helpful. I'm sure our audience has found that extremely useful, where we're at and what we can look forward to in the future. No doubt we'll need a part 2 on this. But I know we've gone over time, but I think we can maybe squeeze in 1 or 2 questions if the audience will allow us. First question, let's go with, can an RCO or BLO be made against any member of the supply chain?
Shall I finish that one off on BLOs, as we've just been talking about them? Yes, a BLO could be made against others. The original intention was that it was to be focused on developers, but there's nothing in the wording to stop that. And you could also go after an architect or a contractor, for example, instead.
On RCOs, the answer is no. It's that short list that we showed on that first slide, which was essentially the current landlord, the landlord as at sometime in 2022, or the developer, or somebody associated with them. So it's slightly different.
I think it's the 4th of February. That's a bit of information I shouldn't have in my head, is it? But it's something like that.
I think that's right.
Yeah.
Great, thank you. Next question. If an RCO is made against a developer, what can it do to recover the money it has paid out from its supply chain?
Well, I mean, I'm sure we can all have views on that. It's then left with its common law rights in the court as a start to try and see anyone else on the project team who they can then go after in the usual way, as if they'd done the work themselves effectively and suffered the loss. I mean, that's a starting place.
And it's probably relevant, isn't it, that the changes that you were talking about, Lucinda, to the DPA, which is likely to give people a relatively wide run at trying to recover against as many people who still are solvent who are working on the project as possible. And that's going to form part of the landscape of allowing you to try to sort of get money from those who you say should be on the hook for it, on the basis of those common law rights under the DPA.
And at the moment, under the DPA, the current law is that a developer can bring a claim as a claimant under the DPA, as well as being a defendant under the DPA. But that decision is, I think, I've lost track. I think that's in the Supreme Court that we're waiting for an answer on that.
That's right. Yeah.
So that may or may not remain the case.
Great, thank you. I think possibly one more. There's been a bit of one come in, a bit factual, but I think we can maybe deal with it quickly. Do you have any advice for flat owners where the building owner has secured the government funding after 2 years, but are taking yet another 2 years to start remedial works?
Well, I think Helena or Lucinda might think there's a clever answer, but in principle, that feels like exactly what a remediation order is for, which was one of the remedies we didn't talk about today. So a remediation order is when you can go to the tribunal and, is it the tribunal, I think, on remediation orders? Someone can check. And can get an order that the works have to be done by a specified time. So that, I think that would be that's the obvious route.
I think that's the clever and obvious answer. Yeah, I agree.
Fantastic. Thank you so much. I think we're going to need to wrap it up there. We're a little bit over, but I hope that's been useful to the audience. Lucinda, Helena, and David, thank you so much for your time today. Before we leave, I just wanted to give everyone a view of what's upcoming on our next webinar, which will be on the 24th of April. Registration will be open soon, but we're going to be looking at closing the books, managing final accounts in JCT and NEC contracts. And we'll have our partner, Claire King, and Senior Associate Catherine Butler with us here then to take you through final accounts. So I hope you can join us then. Please do register, which should be open quite soon. And you can find the QR code there, as well as if you're looking to subscribe to our newsletters, you can join them on our website at that link there. But thank you again for joining today. Thank you to our panel for taking us through that. And we hope to see you sometime in the future soon. Thank you again, everyone. Cheers.
Thanks, Stacey.
Thanks, everyone.